Welcome to Sakshi TV's special immigration show with Attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with Attorney Ms. Prashanthi Reddy in English, on Thursday at 5:30 p.m. EST with Attorney Chand Parvatneni, on Friday at 6 p.m. EST with Attorney Bhanu Ilendra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific consultation, please contact the attorney directly. Ms. Prashanthi needs no introduction. But if you need consultation, please log on to readyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, readyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The readyesq.com site provides you with latest and cutting-edge information on US immigration, law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is about the immigration updates and about H4. So we will continue the knowledge session along with the news and updates on latest immigration followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hello, Ms. Reddy.
Hi, how are you, Tony?
Very well, thank you. Welcome to the show. So,
Thank you.
Ms. Reddy, before we get to the topic, do we have any latest immigration updates for this week?
Yes, the update is what we're going to discuss.
Right.
So should I go ahead?
Yes, please, Ms. Reddy. Please go ahead with the updates and then we'll get to the topic.
So the topic is the update, Tony. So I'm going to go ahead with the topic because this is an update. It's the latest news that we have.
Right.
Okay. So we're going to discuss about employment authorization automatic renewal for H's, E's and L's. So as of today, it's a hot topic because this process starts today, May 4th. So, it's fresh off the press. So just to give you a background before we start, as we all know, previously when H4 extensions and EADs used to be filed, they were filed with H1s, and H1 we could premium process it, but H4s we cannot premium process. So as a courtesy, USCIS would approve the H4s along with the H1s and even the H4 EADs, H4. So everything would come approved as a package because they were sent together in the package. So as a courtesy, they would approve everything together, and so the processing was very quick. And so H4 EAD people, it was like a boon because they could work for any employer. They're not limited by the H1 regulations. So it was a blessing in disguise. But what happened after that is that USCIS started asking for H4 extensions also, all I-539 extensions, including B2 and H4, F1, everything that uses an I-539 form, to get biometrics done. So when that biometrics process started, the H4 processing time started getting worse and worse. So right now the H4 and H4 EAD processing time is 12 to 18 months. So with reference to the H4 EAD especially, this can hit the person hard because no employer will be willing to wait for 1 year for a person to work. So the person might already have a job and they might lose their job because the employer cannot wait for a year, sometimes a year and a half, for the person to come back and start working. So in this situation, a lot of beneficiaries filed motions with courts, and there are a lot of litigation is being filed by various organizations in order to expedite the H4 and H4 EAD processing. So when Biden's administration came in, there was a recommendation by the administration, by the White House, to have premium processing for H4s. So to increase the scope of premium processing to include H4s as well. That would be great if that happens, but it hasn't happened so far, and it's been 2 years, I think, since, or at least last year, beginning of last year, when um, the recommendation came out from the White House. USCIS has still not implemented it. And they are saying that there was an update recently, and they said they could only implement it next year or the year after. I don't remember when, but not in the near future. As a result of litigation that has been filed for delays in H4 and H4 EAD processing, USCIS has come up with a kind of limited remedy for these processing delays, which are completely their doing. And the remedy is that, and this law came out last year, but the update now is that the extension period is increased from 180 days to 540 days. But just to give you information on what the law actually is, for those of you who don't remember or can't remember all the aspects of the law, for those who are on H4, E, or L dependent status, their H4 EAD will automatically get extended for the duration of the I-94 or for 540 days. As per the old law, it was 180 days, or as per the new law, it's 540 days. So again, to tell you what's happening here, if you filed a H4 EAD extension and your I-94, H4 I-94 is still valid, then you will get an automatic EAD extension until the validity of the I-94 or 540 days, whichever is less. So if your I-94 is expiring in 3 years, you will get your EAD renewal for only 540 days, not the 3 years, because it's the lesser of the two. And this is starting from May 4th, the 540-day rule. Previously, it was 180 days, and then they increased it because USCIS has rightfully realized that their processing time is not 6 months or not 180 days, but they're taking actually 12 to 18 months to process cases. So the 180 days increase was really ineffective and not useful. So they have increased that rightfully so. So now that we have established what the automatic extension is and in what situation the automatic extension of H4 EAD is given, we need to discuss what documents are needed in that situation. What documents are needed to show that you're employment authorized, because USCIS does not give a temporary EAD approval. And you need some kind of document to show your employer or for your employer to enter it into the I-9 for the I-9 purposes. USCIS has said that you need a combination of documents. So the first document is the I-94 797 or I-94 unexpired I-94 to show that your H4 has not yet expired. The next document is the I-797 receipt copy to show that you filed an EAD extension. Now this receipt copy will usually give you information about that extension. So it will say that your EAD is extended for 540 days. Or if you have filed before today, then it might just say that your EAD is extended for 180 days. Either way, that receipt can be used for extension to 540 days. Now the start date, the 540 days, day one starts on the expiry of your EAD. So that's how you calculate 540 days. In addition, the other document that's needed is the expired EAD card. So you need the expired EAD card, you need the receipt of the EAD application, and you need the unexpired I-94. So all these are 3 documents if you have, then you'll be able to automatically extend your EAD, and you can show those documents to your employer. Now, the good thing in this law is that USCIS has finally agreed that dependents of E and L visas don't actually need an EAD. So they don't even have to file for a 765. And this was always been the law, but USCIS has refused to acknowledge it, and they forced dependents of Ls and Es to file 765 applications. So that's not needed. Now they have agreed that they are automatically employment authorized, so they don't need to file any kind of EAD, so they don't have to worry about the expiry of the EAD. So as long as they are in valid L2 status, and that happens if their spouse is in valid L1 status, then they qualify for work authorization. That is great news. Also, just to give you some more information about the 540 days increase in time, this is a temporary extension. So the 540 days is applicable only until October 26th, 2023. So I don't know why they came up with the date October 26th, but they want to give 540 days only until next year October, because they're presuming that by next year they're hoping that they will come back to speed on their H4 EAD processing times. So they're hoping that it'll be less than 6 months. So what's going to happen is that it'll revert back to the 180 days from the 540 days in October of next year. So that's one thing. The 540 days extension from 180 to 540 is only until October 2023. Who is eligible for the 540 days? Anyone who filed a EAD extension before May 4th, anybody who is filing an EAD extension now, and the extension has not yet expired. Again, previously filed EAD extensions also should be EAD extensions that were timely filed. So whether you filed earlier or you filed now, you automatically get the 540 days. But of course, that 540 days is not going to count as 540 days from today, but it will count as 540 days from the date of expiry of the EAD. So that is, Tony, in short, what the H4 EAD extension is all about. The automatic extension is all about.
Right, right. So thank you so much for the update, Ms. Reddy. So we've received some questions regarding, H1B visas and I-485. So can I move on to those questions?
Sure. Go ahead. Happy to
Right.
answer them.
Right. So could you, I'm starting with the first one. Could you explain to us the effect of H1B on denial of I-485?
Oh, the effect of a H1 on a 485 denial.
Yes.
So there's no effect on a H1 if the 485 gets denied, because the person is in valid non-immigrant H1 status. The 485 is an application for a green card. So even if the 485 gets denied, the person can still continue living in the US if his H1 has not expired and if he's maintaining H1 status.
Right. Right. So, and the next one is, can one leave their sponsoring employer after they file the I-485? Is that possible?
So there is a rule for that, and there are certain terms and conditions that apply. As per the AC21 rule, if the I-140 has been approved and if the 485 has been filed at least 6 months ago, then you're eligible to move from one employer to another, provided that the other employment is same or similar to the previous employment. So they don't define same or similar, so we just have to look at the dictionary meaning of it. So obviously it doesn't have to be same, it can be similar. I would suggest that in an IT profession environment, pretty much any IT related job is similar, as long as you're not going into management, but you continue to do you do software developing, designing, etc. Even if the job title is different, I would think that it will be fine and it comes under the AC21 rule. So those are the terms and conditions for moving after the 485 has been filed. But at any given point of time, Tony, there always has to be an employer or an offer of employment attached to that 485. So you cannot at any point of time not have an offer of employment, because then the 485 has no basis to exist and it will get denied.
Right, right. So, Ms. Reddy, moving on to the next question. Can one change their employer while their I-485 is pending? And, will it affect the validity of their I-140?
So I just answered that question. I guess it's the same question put in a
Yeah,
different way.
right,
So the I-485, yes, you can change the employer while the I-485 is pending, as long as what I mentioned, the terms and conditions are met. And as I said, H1 is not affected by 485, so H1 remains as is.
right, right. And what happens when someone wants to go back to their home country while their I-485 is pending? Can they adjust their status in their home country?
So if depends if it's a temporary visit, a temporary visit I guess would be less than 6 months. So if it's a temporary visit, I would suggest that what I'm suggesting is they could leave the country and still come back into the US and continue with their 485, as long as they don't miss any deadlines. For example, if there's biometrics due, then they have to come back for biometrics. If they filed an advance parole, then if you leave the country, most probably that advance parole application will not be processed. Therefore, in order to come back to the US, you would then have to have a valid visa, some other non-immigrant visa, to be able to come back and then continue the processing of your 485. But I think your question was more towards if they plan to leave for good or leave for a long protracted period of time, maybe for a year or 2 years, then what happens with their 485? In that instance, if the 485 does get denied for that stated reason, for the reason that they're not living in the US anymore, then and if their priority date is still current, then they can apply an immigrant visa with the National Visa Center, and there is a processing that takes place very similar to the 485. You have forms, you have documents that have to be submitted, medicals, police clearance from your home country, and then finally you have an interview at the consulate in Mumbai if you're in India, and then an immigrant visa is approved for you, and you come into that country using that immigrant visa, and then when you come in, you're processed at the airport for a green card, and then you get your green card in the mail. So that's the process if you want to switch from a 485 to NVC processing. You'd have to withdraw that 485, I guess. Unless it gets denied, then of course you don't have to withdraw it.
Right. So, and what is the processing time for an I-485, Ms. Reddy?
Processing times vary depending on when we are talking about it. That keeps changing. But presently, I mean, it's about 12 to 18 months, but we've seen that it's taking much longer. Because COVID and all the travel bans, the previous travel bans by the Trump administration has really affected USCIS. Also, USCIS is trapped for funds. All that has affected USCIS and the processing times. And so we see cases that were filed in 2020 are still being processed. Of course, what happens with the 485 Torni is when we file them, either the priority date again becomes backlogged, so they remain pending for years together because they
Right.
cannot process them until the priority date is available. But if the priority date is available and if it's current and if there are no issues, it should get processed in 12 to 18 months. Maximum 2 years is the processing time right now.
Well, I think that's the hope. So,
Yes.
how long can a person stay in the US, Ms. Reddy, after their visa expires?
They're not supposed to stay in the US well, there are two things. When you say visa, it can be interpreted in two ways. Is it the I-94 or is it the visa that's stamped in the passport? If it's the visa that is stamped in the passport, which basically allows you to enter the country, uh, then we don't care even if it expires. If you're in the country, you can continue to stay as long as your I-94 is current. But if your I-94 expires, then of course you cannot stay in the country. The visa is only needed if you're traveling back into the country, then you need to worry about the visa expiry.
Right, right. And how much cost is involved for the filing of I-485?
The USCIS fee is $12.25 for an adult applicant, and I believe for a child under 14, it's $12.25 minus $85 because they don't have to pay for the fingerprints. So that is your cost for each person in the family. So if you're filing a 485 for 4 people, then it's that times 4. And also you'll have costs associated with attorney's fees, of course, and then you'll have costs associated with the medicals because you have to get medicals done for each member of your family.
Right, right. So another question that we got is, what if I get laid off before getting the green card and my I-485 is pending? How can I handle this?
So we can use AC-21, and then you can transfer to another employer as long as it meets the parameters of the AC-21. That is, I-140 is approved, 6 months is over since the date of filing of the 485, and your job is same or similar. So you can always move to a different employer. As I said, there is a need that to be associated with some employer or the other because it's an employment-based green card and it's based on a permanent job offer. So there has to be a job offer at any given point of time. Whether you actually started working for that employer or not, there at least has to be a job offer.
Right, right. So, Ms. Reddy, what is needed for filing of Supplement J?
So the 485J is what I presume you're asking about. And the 485J is the offer of employment, like we said. When you're doing an AC-21 and you move to a different company, you have to notify USCIS. So in order to notify USCIS, earlier you just had to send a letter. Now they have a form called 485J. So instead of sending a letter out, you have to fill out that 485J form that has to be signed by the employer as well as the beneficiary, and that 485J details the job, gives details about the job description, the job title, salary, employer's contact information, employee's information, and this is signed by both the employer and the employee. So it's like an offer of employment. So that is important when you're doing the AC-21. So that's what is required for a 485J. 485J, by the way, Tode, is also used in interfiling cases.
Right.
So in an instance where you are asking for your 485 to be transferred to another I-140 because that other I-140 has a better priority date, and you want the same 485 to keep the same 485 but just to change the I-140, the underlying I-140. In that instance, if the I-140 is already approved, then it's important to send a 485J to show USCIS that the offer of employment still exists. So in that instance also we submit the 485J. It's an offer of employment basically.
Right, right. So, moving on to our next question. What happens if I'm not working on an EAD?
It's fine if you're not working on an EAD. It's not a H1, so you're not bound to be working every single day because it doesn't have those strict H1 regulations where if you don't work even for a day, unless it's for a valid reason, you are out of status. On an EAD, you can work for any employer and you can choose not to work. Say if you're on a H4 EAD, you can choose to be in and out of jobs, take a break, do whatever you want. But it's a little different for a 485 EAD because on a 485 EAD, as I said, there has to be an offer of employment, number one. And number two, USCIS expects that you're working for that employer. And if you're not working for the employer, there should be a reason why you're not. So it's tricky not to be working on an EAD if it's based on 485 because you want to safeguard your green card and ensure that the 485 does not get denied because USCIS is suspicious whether a valid job offer actually exists or not. So that's a little tricky, but any other EAD you can choose to work or not work. You don't lose the EAD because you're not working.
Right, right. Also, Ms. Reddy, could you explain to us the age out CSPA for children immigrating to the US?
Yes, we're getting a lot of good questions today, all about 485 and
Right.
all these. I know these questions are what people want to hear because I get them all the time for my
Right.
clients, etc.
Right, Miss Reddy.
So, with reference to CSPA, it's a limited law which allows kids who have already aged out to deduct their age. So, say somebody is turning 21 in, say, 6 months, and the 485 has been filed, but the visa number was not available at the time of filing. The 485 was filed based on dates for filing, which is like, a method of filing the 485 when the visa number is not available. So if it's filed in that way, then if your child is aging out in 6 months, say your I-140 took a year to get approved because there was some issue with the I-140. It usually doesn't take a year. Even if you do regular processing, it maybe takes 6 to 8 months, even nowadays. And premium processing takes 30 days, a month to sometimes even less than a month. But say it did, then you're allowed to deduct the processing time of that I-140 and deduct your age accordingly. So if it took a year for the I-140 to get approved, you can deduct the year from the age of the child. So now your child will be aging out a year and a half later, and hopefully by then either your priority date should become current or you should, have gotten your green card. So whichever it might be, then your child will not age out. That's what CSP is about. Deducting the time that it took for your immigrant petition to get approved.
Right, right. So, Miss Reddy, my last question is for the show for tonight. Is what is the difference between consular processing and adjustment of status?
So there are a couple of steps usually for a green card process, especially if it's employment based. You have to file a labor certification in most instances. In some instances, you don't have to. And then you have to file an I-140, and then you have to file either a 485 if you're adjusting status, which means if you're already in status here and you're adjusting to a green card, then you can file a 485. But say you're outside the country, then you cannot file a 485. You have to file a petition for an immigrant visa. And that is done not through USCIS, but through NVC, the National Visa Center. And the application is really done online and all the documents are submitted online. Once the NVC is satisfied that all the documents are submitted, they then forward that to the consulate. The consulate will then review all the documents and ask you for additional documents if they need any, and they'll set up an appointment for you. That's called an immigrant visa interview. And at the time of the interview, they will get your signatures, make sure you have all the documentation, ask you the relevant questions about your employment. And they will, if everything goes well and if the visa numbers are available, approve an immigrant visa for you. That immigrant visa allows you to travel into the US, but once you come into the US, you're processed for a green card and you get the green card in the mail. So you become a permanent resident. That is the difference.
Right, right. So, thank you so much, Miss Reddy. With that, we come to the end of the show for today. And as always, thank you so much for your insights, for all the value that you add to our show and all the information that you share with us. It's a privilege hosting you.
Thank you, Thorny. It's a pleasure as always to be hosted by you. Thank you.
Right. You're watching Sakshi Live. This is Thorini. Thank you.